The broadcast is now starting. All attendees are in listen-only mode.
Good morning, all. My name is Preston Bucady. I'm an attorney and consultant working on behalf of IT Governance USA. And today we're going to be talking about the California Consumer Privacy Act, a often discussed and much touted new piece of legislation coming from our concerned friends in California. Always something that they're aggravated about. But we'll be talking law and sort of its development, its impact, its requirements for businesses, and where it fits within the greater framework of privacy and cybersecurity laws, both nationally and internationally. Our presentation is scheduled here to start at the top of the hour. It's currently 11 a.m. where I'm located in Denver, Colorado. So 12 p.m. Central, 1 p.m. Eastern. We're going to give it a couple more minutes here just in case there are any late joiners. So we'll give it a couple more minutes, like I said, just to allow for some people to join, and then we'll get kicked off on our presentation today. Do I need to comply with the California Consumer Privacy Act? Bear with us for just a couple more minutes. We'll allow some people to join late, and we'll get kicked off here. Okay, all. Thank you for joining. Again, welcome to those of you that have joined, and for those of you that are still joining us. My name is Preston Bucady. I'm an attorney and consultant who works for IT Governance USA. I travel around the country, based out of here in Denver, Colorado, like I said, but travel around the country counseling clients on how to comply with various cybersecurity and data privacy laws and how they can align their compliance programs, if they have one, to any sort of accepted, mature standard that's out there, the NIST standard, ISO, and others. So today we're going to be talking about a very new law that's on the regulatory landscape. It's coming from our friends in California. It's called the California Consumer Privacy Act, and there's various provisions of this new law that relate to data governance and sort of this cross-functional bridging between cybersecurity and data privacy. And so again, this law is looking specifically at privacy. But as we'll see over the course of the presentation, there's actually existing laws on the books in California that deal with cybersecurity topics around data breach notification and security, et cetera. So we're going to see how this law sort of evolved, where it fits within the greater paradigm, and then, of course, do you need to comply? And if so, what do you need to start doing? Because hopefully, as you all know, the law will take effect in January 1st of 2020. So closing on the end of this year for when this law will become operative. And then the California Attorney General will have a short period of implementation before those laws will actually start to be actively enforced. Now, before we get too deep into our programming, I just wanted to stop here with a quick word from our sponsor. IT Governance is a GRC one-stop shop. So we help manage with a variety of services and activities around governance, risk management, and compliance. Like I said, from the sort of counseling and consulting activities that someone like me may be engaged in, all the way down to actual technical implementation of things like penetration tests, onboarding of ISO frameworks, audit and certification processes, and then a variety of other software tools, employee awareness training, qualification and certification courses. As you can see, a variety of products and services aimed around generally governance, risk management, and compliance, but more specifically how that relates to your IT network, your information security infrastructure, and the actual governance of the data that you process on a day-to-day basis at your organization. So today's agenda. First, we're going to go over a high-level overview of the types of cybersecurity laws we're starting to see, not only that are already in effect today, but some newer ones that are coming out of the pipeline. For those of you that are really on top of this news, you'll notice that just the other day, Utah released its own new privacy sort of a law. We'll then turn and pivot to start to focus more narrowly on cybersecurity laws and privacy laws that apply specifically to U.S. companies. So again, walking back from that high-level paradigm of what the international approach is to this and getting more drilled down to the U.S. specifically, and then we'll move down and become more granular, right? Does your organization need to actually comply with California's new law? If not, or even if so, what are some other potential state laws that may be catching you in terms of data governance activities, again, whether that's cybersecurity or data privacy? And then finally, where do you fit this all in? If you find yourself dealing with a patchwork of regulatory responsibilities, how can you try to comply with everything and yet nothing all at one time, right? And without building an overly complicated compliance process that's focused too myopically on individual laws, trying to get a more sort of a framework or a programmatic model for compliance in place to help you comply with CCPA responsibilities where those apply, but then other global responsibilities that apply in other jurisdictions as well. So to get us started off here today, I just wanted to give a very quick sort of a high-level overview of the existing types of cybersecurity laws out there in the United States. Hopefully, if you're an organization that's operating in the United States, you're already familiar with local state data breach notification laws. All 50 states have laws related to data breaches and data breach notification, and generally speaking, they relate to the requirement on organizations to have to notify either the state attorney general or some sort of other regulatory enforcement body within that state when there is a data breach, and or additionally, having to notify actual affected users, right? So your consumers, your customers, your end users, and then the various sort of specific requirements around when those various notifications are needed and what those notifications need to look like, right? So literally the form of the notification, the content that needs to be included in the notification. Also a very interesting topic that some of the US attorneys at IT governance have argued over with internally as we all sort of try to understand where our country is headed on this topic. Data breach laws are interesting because, as you will see, especially again if your organization operates in multiple states, there are various thresholds for when those actual laws are required, right? And so in some states, there is a requirement that data breaches, say to the actual affected end users, are only required when there is a substantial risk of some sort of a privacy implication, right? A risk for identity theft, a risk for loss of economic ability or an economic impact caused by the data breach, or more generally, like I said, just sort of a privacy risk, right? A substantial articulated harm, whereas other states have a little bit more nebulous definitions on what exactly is a harm and when that harm rises to a sufficient level to require notification. As a result, again, it's something for you to consider. If you're operating in multiple state jurisdictions, you are likely already today subject to multiple, sometimes competing requirements for data breach notifications. Now, on top of that, again, we also have some other sort of cybersecurity or more generally just security focused laws. And this is an interesting time in the IT world where security and privacy are almost being forced to become bedfellows here, because traditionally they may have operated in separate silos. And that's why you can sort of see this approach here, right? We actually have laws like the New York Department of Financial Services rule that strictly relate to cybersecurity. And they deal with the security of your networks, your infrastructure, and your information. Generally talking about how you maintain and protect and store that information, right? Now, on the flip side, we actually have privacy laws. These laws are not necessarily looking at the security of information. And in my mind, I think of it, I analogize it, cybersecurity laws are kind of more like the nuts and bolts, the technical, the sort of stuff you can drill down and tighten. Privacy laws are kind of a new theory to us in the United States. Historically been a very recognized right in Europe and other places around the globe. And not to say that it is not a theory in United States jurisprudence, but it's not actually an articulated right. We don't actually have an amendment to the Constitution that guarantees all of us a right to privacy. It's sort of been interpreted through understandings of case law and various other amendments to the Constitution. And so privacy as a topic, as a theory, is much more aimed around the value of the information, right? Not just protecting the network that it's on, but the actual value, the inherent value of that information therein. As a great example, social security numbers. Increasingly in our day and age, social security numbers are being used as a part of a two-factor authentication process. And you may be familiar with this already, right? You call your bank, your credit card company, or any other sort of a service provider you may use on a personal level. They often ask for the last 4 digits of your social security number to help authenticate that you are the correct user trying to get into the account, right? Well, the issue with that is that that sort of an idea, that modality, places an inherent value on the social security number, which may not have originally existed. So for those of you who don't know, when social security numbers were created originally, they were meant to be sort of a secondary identification, right? In that way, almost like a serial number, kind of like a dog tag for citizens in the United States. And there was not meant to be any sort of a value in the information. So the idea was, back in the 50s, if I wrote my social security number on a scrap of paper and I left it at a restaurant, no harm, no foul. The only thing someone could do with that information is literally identify me, right? Social security number, ABC, blah, 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 is Preston Buchanan. Well, now companies are placing this value on that social security number, right? It's used as an authentication mechanism on top of an identification mechanism, and thereby it's creating a secondary value, right? Now there is a reason for hackers and other nefarious agents to try to get a copy of your social security number, not because of the inherent value in the number itself, but because they can essentially use that as a password to try to get into your other accounts and services. So when we talk about privacy laws, it really is looking at that more inherent value of the nature itself, right? How can we use the data that we have to either directly or indirectly an actual human being, and what are the implications for that human being, right? Especially as we consider the various data breaches that have come across the news headlines over the course of the past couple of years. Sony, Target, Equifax, Facebook, Yahoo, and others. You can think of no shortage of information that on its own may not provide much value. Your email address, your physical address, your driver's license number. But in conjunction, when it's all out there floating in this ether, all of that can be incredibly invasive. People can start to use that to build profiles on you, to sort of live in your identity, right? The idea of identity theft, and then other sorts of bad acts that we may not even have totally appreciated yet. So that's sort of the fundamental difference. Again, there's this historical difference between cybersecurity or sheer security and actual privacy. Increasingly, though, those worlds are being blended together. In the United States, we are all intimately familiar with this. If you've had the displeasure of having to go to a doctor or hospital in the past 10 to 20 years, you have undoubtedly dealt with HIPAA, the Health Insurance and Portability Accountability Act, that deals with the collection, storage, and processing of protected health information, or PHI. And so in that way, that law actually relates to both privacy and cybersecurity, because it outlines security requirements that must be in place at an organization that handles PHI. But it also deals with how that information needs to be secured, segmented, and sequestered in order to maintain the private aspects, especially the private aspects of that real health-related information, right? Our biological functioning, that's something that digs at almost a surface layer deeper than, say, our basic contact information or billing information. Now, that same fundamental paradigm is now growing. It has blossomed into a full fruiting tree of legislation around the globe. Surely all of you are familiar with Europe's General Data Protection Regulation, or GDPR. That law, again, dealing with both security and privacy. While it is actually called the General Data Protection Regulation, you can see how there are elements of security wrapped up in that law, say under Article 32, which we'll discuss more in a minute, but then also elements of privacy, right? Recognizing the inherent risk that comes with dealing with personal data, and as a result, requiring organizations to adopt a risk-based approach to actually managing privacy impacts, right? So not just actual security and the structure of your networks, but also the privacy, the value, that inherent value of the data you're collecting and dealing with, right? Now, you see there at the end of this slide, the very bottom, the CCPA, that's the acronym that's commonly being used now in industry to denote the California Consumer Privacy Act. So as you see that acronym, not to say that there aren't others which can represent the California Consumer Privacy Act, but CCPA is kind of becoming the standard acronym out there for the California Consumer Act. So that, again, is what we're, of course, talking about today. And before we get drilled down too much into that specifically, I just want to mention some other things. Cybersecurity laws in the United States are sort of, again, they're at sort of a patchwork stage. Whereas the GDPR, as a regulation, has set a common standard across all of the independently operating economies in the European Union, Britain and their current Brexit woes aside. The issue with the United States is we don't have a single standard, right? There is no federal model for privacy in the same way there is federal models for complying with, say, food and drug safety or transportation safety. Right now, we're left with this patchwork of state laws, like I mentioned, which typically are going to apply to all companies doing business in that state and or other states. And so you can see how you may have tendrils located in various states across the country that have different sorts of requirements, but also there are sector and industry specific cybersecurity laws as well. So we're talking, when we talk about public companies, you may be under obligations to deal with privacy issues related to the SEC and accounting and accountability. You may be under security requirements under FINRA, the financial regulatory body that helps manage financial institutions. We saw the New York Department of Financial Services rule that deals with companies based in New York that provide financial services, not just thinking banks and that sort of traditional modality of finance, but also insurance companies, lenders. If your company is engaged in net 15 or net 30 lending, perhaps you're falling in under the NYDFS or other associated rules, right? We talked about healthcare law with HIPAA. So as you can see, the current state of what I'll call data governance law in the United States is a patchwork of coagulated and not entirely cohesive responses to issues that are happening and being addressed on a state level. right? So as you can imagine, especially like I said, with all these headlines on data breaches coming out constantly, states, individual legislators in their states are responding to the needs of their constituents. They are crafting state legislation to help tackle this topic, frankly, in the absence of any movement on it from our federal government, which, to be somewhat cynical, I don't see our federal government, moving much on this topic over the course of the next year, because keep in mind, 2020, it's going to be a big election year, right? So as you can imagine, presumably we're going to start pumping the brakes on any real fundamental government work come November of 2019, so that all of our high-paid legislatures can go off to Washington and begin the annual campaign process. So for those of you that have been entirely satisfied with the development of our government over the past 4 years, good, bad, or otherwise, get ready, because we're about to push pause in November of this year, and we're going to be blessed with a year's worth of commercials and debates and other exciting information in the absence of substantive legislative development. Now, again, that's just my cynical opinion. We'll see if that actually happens. I'm hoping that what we will see over the course of the next year, 2 or 3 years, will actually be a federal cohesive standard that applies to data governance across the United States. So we'll get rid of this patchy interpretation of legal requirements that depend on what state you're in, what state you do business in, what industry you're in, and also what data you deal with, all separately at the same time, again, potentially competing or conflicting responsibilities, and instead establishing a sort of higher level bright line standard. Again, increasingly important in today's interconnected business environment. You likely, as an organization, are operating in more than one state by virtue of internet commerce or just communications. And so presumably, you're trying to deal with a patchwork of laws around the states. Wouldn't it be nice to have one single standard like they have in some of these other countries? So again, presumably you've all heard of Europe's GDPR. That was a huge one that sort of sent shockwaves through the industry when they started talking about it in 2015, when it was released in 2016, and then certainly no shortage of blogs and news articles on top of implementation guides and what other services you could find on the internet in advance of the May 25th, 2018 implementation date for GDPR. So we are now living in the GDPR world. We are swimming in its wake. If your organization has not dealt with the compliance issues presented by GDPR, I would politely recommend that you hang up on this call and go back and start to think about those issues. Over the course of our discussion today, you'll see how there's areas of overlap between that law, these, and California's. So the idea is that while California's law is not going to be a mirror image of the GDPR or, say, the Indian Data Protection Act, it will have some of the same fundamental theories. And so as you build up your internal compliance processes to help operationalize and give effect to this law, you'll want to start to consider the same sorts of ideas. Again, so we'll talk about those in some detail, but you can see some other countries joining the groundswell of emotion after Europe took the charge on this. So in Asia, we've got a variety, a smattering of laws that deal with data privacy, data governance, and cybersecurity. Some even go further into the idea of data localization, like Vietnam, that you don't see listed here. But again, so you've got this whole economic ecosystem over in Asia where various countries are coming up with their own sorts of laws in Japan, Taiwan, Thailand, and others. At the same time, we're also seeing that in some of the developing nations, right? Brazil, India, Russia, and China have also released their own various interpretations of laws that either collectively or specifically deal with cybersecurity and data privacy, data localization sometimes coming into effect there as well. So again, you can sort of see, if you look at this stuff from a higher level, how all of these other countries are jumping on the European bandwagon to start to put in place some sort of a legislative fence, some sort of a liability moat that we can draw around organizations and around our own behavior to start to try to determine, hey, what is actual good and bad behavior when it comes to data and data use and data processing, right? And again, as you can imagine, a lot of this stuff has already been formulated and figured out in other industries, food safety, vehicle transportation especially, right? There's already a well and established and robust insurance model that's based around liability and fault and what is reasonable behavior and what isn't, we're starting to go down this path with data governance. And so you can see again how all of these laws are coming up at sort of an industry level, a sector specific level, a local, regional, or state level. Eventually they get elevated into a national level like this, and presumably someday we may even be presented with an international standard in the vein of an ISO or something to that effect. In fact, the GDPR has specific carve-outs that there may be a certification mechanism or other sort of compliance mechanism that you don't have to go through and demonstrate compliance with the law. You just follow a framework, get a certificate, and you're done. Some US laws are coming on to that idea as well. In November of last year, Ohio released a law, Senate Bill 220, that indicated companies that suffer a data breach can rebut a presumption of negligence by demonstrating that they follow an industry standard security model like NIST, like ISO, or others. So again, this idea that we're trying to figure out, hey, what exactly is good data governance? And then in turn, what is bad data governance? How can we figure out the difference between the two? And then how can we start to draw lines of liability so we can hold people accountable for their bad behavior? Well, in that vein, we've got the California Consumer Privacy Act. Now, as you can imagine, California was the first to jump on this issue for two reasons. Number one, as a historically liberal state, California has often taken a lead on progressive laws. As you can perhaps remember, things like car emission standards, right? California came out with some of the toughest, and as a result, automakers around the country had to sort of effectively adopt that standard because of the sheer consumer size of residents in California, right? So number one, that's why California is jumping on this act here. It's because they have so many potential voters within their base that they can sort of lead the way on this topic. Now, other states have that power as well, New York, Florida, Texas, so you can think of those big ones that are often coming up in election years. Those are the ones that, by virtue of the size of their population, they can set a standard, and then if a company already has to meet that standard, say for several million consumers, why not roll it out across the country, right? So that's number one. Number two, much more realistically, California is home to a variety of businesses whose entire economic model is based on the commercial use of personal data. I'm not going to name names, but surely you can think of companies based in the Silicon Valley area who make billions of dollars every year on the surreptitious collection, processing, and storage of your personal information. You know, and frankly, with limited degree of insight or control from your point of view. The idea is that we need to protect the economic interests of those companies, right? They're California constituents, they do a lot of lobbying, they spend a lot of money, they pay a lot of taxes. We got to make sure that we are enforcing those rights. So actually, to give you guys a bit of brief history on the topic, what actually happened with this law is that a real estate developer by the name of Alastair McTaggart, based in San Francisco, a couple of years ago got interested in the topic of data governance and the idea of surveillance capitalism. It's a term that's somewhat pejoratively applied to these sorts of companies that have created an economic model that allows them to offer a service for free or for cheap in exchange for us, the users, actually giving them our data. So in a way, they've sort of perverted the traditional model, and we are actually no longer customers. We are actually the commodity being sold, right? And the customers are marketing companies who interface with these internet service providers, internet social service providers, as it may be termed. And as a result, again, the internet social service provider is providing a marketing service to other companies. These companies are paying for the marketing service. They're the customer. We are actually the commodity being bought and sold. Our insights into our purchasing behavior, our actual behavior, our political preferences, whatever the case may be. So Alastair McTaggart, researching all this stuff, rich guy based on his activity in the real estate world in San Francisco, right? You know, hardworking guy. So he goes, hey, I don't really like the way that this is going, and I'm going to do something about it. And he took it upon himself to hire a team of consultants to engage in the legislative drafting and lobbying efforts required to actually create a California law. And so they did that, and I'm thinking here back now to 2016, 2017. These folks got together and they created an actual law that dealt with the governance of private or more appropriately termed personal information in California. Now, the original measure proposed by Alastair McTaggart was potentially troublesome to businesses in one primary way. I should actually step that back in two ways. Number one, the first issue was that the definition of personal data that Alastair McTaggart created was incredibly broad, and it, as a result, encapsulated a lot of activities that were currently going on in the Silicon Valley area, right? So a lot of activity is now under scope of this new law. And then to take it a step further in a worse direction from the point of view of an organization trying to manage liability, it actually gave a private right of action to aggrieved consumers. So the idea was not just that an attorney general could seek enforcement of the law, but actually any individual consumer could seek enforcement of the law. What does that mean? That means any consumer can sue your company for violation of the law. If you're selling to millions, or in the case of some of those internet social service companies, billions of people, that is a potentially astronomical unknown amount of liability, not only in terms of actual litigation that proceeds to a courtroom, but also, as you can imagine, all those daily operational sorts of processes you need to manage just to keep all of that stuff under control, right? Responding to consumers, getting out in front of issues, et cetera, et cetera. It was going to be a colossal effort. And as you can imagine, these companies that have armies of lawyers and billions of dollars in their buckets, they were not going to have that. So in the summer of 2018, they started lobbying the California legislature. And at the time, it started to seem like, attention, or I should say interest in Alastair McTaggart's version was being pulled away to the more corporate version being put together by this professional group of consultants, right? Okay, well, consider, again, we're in 2018. We now sort of have two versions of this law coming out, one sort of coming from movement, very progressive in terms of the rights that are allowed. The other one coming from industry, a little bit more tighter, a little less rights, not quite as effective. Well, what happened in March of 2018, and I hope I'm remembering my dates right because it could have been March 2017, regardless, it was the Facebook Cambridge Analytica scandal, right? You guys remember that in the news, obviously a massive, massive news scandal. In fact, its ramifications are still worming its way through our news cycle as of today. And so what happened, by virtue of this Facebook Cambridge Analytica scandal, there was a groundswell of public support for Alastair McTaggart's proposal. And the interesting thing about California is that not all laws need to go through a legislative process. They actually have a mechanism that allows laws to become law based on a ballot initiative. So if you have a proposed law in California, you don't need to take it to the legislature in Sacramento. You can take it straight to the voters. Now, there was expected to be a vote in fall of 2018. Prior to the Facebook Cambridge Analytica scandal, all of these companies that are consulting and drafting a more business-friendly law are quite confident. After the Facebook Cambridge Analytica scandal, their confidence has dropped off dramatically. Again, public interest in the topic is swelling. Support for technology companies in California is dropping. People have become critical of their business practices, critical of the way they manage not just the privacy of their information, but also how they manage their companies, right? A real sort of a public outrage. And as a result, Alastair McTaggart's ballot proposal was polling at something like 60 to 70% approval ratings. The legislators in California and their rich constituents in Silicon Valley were not at all confident that they would win in November of 2018. They thought that if it went to a ballot initiative, McTaggart's version would win. So what are we going to do to get McTaggart's version out of the way? We have to come up with something that meets in the middle. And that's precisely what they did. Over the course of June and July last summer, these people got together, they constantly met with McTaggart and his team, and they tried to sort of split the middle and come up with an approach that effectively enforces privacy rights for consumers in California, while also giving a somewhat lenient or at least business-friendly approach to the actual management of this issue and the resulting liability that comes about, right? So as a result, we get the California Consumer Privacy Act passed in 2018, again, taking effect in January of 2020. Portions of that law are variously found within the California Civil Code. You can find that online very easily through the official California websites. And then you can start to break down the actual provisions of the statute, right? And you'll see, how do they define personal data? What are the rights that apply to consumers? What are the responsibilities of businesses who are considered covered entities under this law? What does it all sorts of mean? Let's get into that right now, right? So you guys are all here because you're trying to figure out, do I have to comply with this new crazy law? Two things to sort of consider, right? Your material and territorial jurisdiction. And without getting too deep down the rabbit hole in terms of the legislative and legal rationale of what those terms mean, fundamentally you need to focus on this. If you are a business that operates for profit doing business in the state of California, right? You either have a physical presence or you have contacts with that state, you will probably be subject to this law, except for these thresholds right here. So these are the important thresholds to consider when you look at material jurisdiction. Your company has to comply if you have at least $25 million in annual revenue, or if your company commercially sells or shares the personal information of at least 50,000 consumers, or if over half of your company's revenue comes from the sale of personal data. So something to consider there. Again, there is a threshold set. We're kind of focusing on larger businesses, right? We'll give a carve out for small businesses there based on that $25 million annual revenue size. The other important thing to consider here is that this law is really intended to be aimed at companies that commercially benefit off of personal data, right? You see there, if your company has half of your revenue coming from the sale of personal data, the law applies to you. Or if you are collectively, either alone or in combination with another group, selling, collecting, sharing the personal information of 50,000 people or more, right? So something to consider there. If you have more than 25 million in revenue, or if you're engaged in the commercial dealing of personal information, you may be subject to the material jurisdiction of this law. Now keep in mind, you see there at the bottom, processing is actually defined in statute 1798.140. Oh gosh, I don't remember the exact one, but it's in section 140. Processing is defined as any operation or set of operations performed on personal data. So almost anything you can do to data would be considered processing. That's not exactly the critical distinction. It's really how much does your company benefit from that processing. Now, like I said, it also involves an element of territorial jurisdiction. Now, this one will presumably be a more complicated and tricky one for businesses to figure out, because you will need to comply if your company or if your organization does business in the state of California, regardless of where it's located, right? So as always, if you had any sort of an establishment in the state, a headquarters, or you're incorporated there, you will automatically be subject to the law. But if you are doing business in the state, you will be subject to the law. However, that is only to the extent that your business processes the data of California residents. So essentially, guys, what I'm trying to say there is if you are an organization located outside of California, but you have dealings in California, those dealings, as they relate to California residents and their personal data, would be subject to this law. So something to consider there. And especially that gets more tricky when you start to talk about a national company operating at a national level, national marketing campaigns that maybe aren't directed at California specifically, but it does involve California consumers. How does that come into play? All of that will presumably need to be sorted out based on case law and judicial interpretation. There are a couple of cases that actually went through the California Supreme Court and the United States Supreme Court that deal with the topic of specific personal jurisdiction and general personal jurisdiction. They may give you some insight into where the courts are going to go with this. And for those, I would recommend Bristol Myers Squibb from, I believe, 2017 and Daimler AG from 2018. Feel free to reach out to me after this call for actual case citations. I'm happy to email those out or point those to you on the internet. But yes, to answer the question that just came in over the line here, this is within the state of California, right? So the idea of extraterritorial reach is not necessarily going to apply, and the Supreme Court has very sort of forcefully in the past, even in the past couple of years, come back to the state Supreme Court in California and said, hey, California, you cannot apply your laws everywhere in the country just because other things happen to be similar. You can only apply your laws as they relate to harm that has occurred based on actions in your state. So again, I would advise you, this is more drilled down to how are you processing the data of California residents? The question for you then becomes, can you sort those people out, or do they just come in as one big bucket of end users or customers? Can you really start to segregate that stream of California residents only? That presents a level of operational complexity here, right? And again, that's why perhaps don't focus on this law specifically, elevate yourself to the theories and start to prepare a programmatic model for compliance as opposed to, say, a check-the-box compliance initiative with CCPA specifically. So now that's the jurisdiction of the company, and just to bring it back to you again, some questions to ask yourself. Does the CCPA apply to me? Do I need to comply? Well, do you have more than $25 million in annual revenue? Do you process or store personal information on at least 50,000 people? Or does your company make more than half of its revenue by selling personal data? If you can answer yes to any one or all of those questions, you may need to start to prepare to comply with this law. Now, at the same time, does your company process the personal information of California residents? Do you sell to California residents, or do you collect any of their information? What is your level of contact with residents in California? That will also give you an indication of whether you need to comply with this law as well. So whether it's by virtue of your entire organization or just the contacts you have with California, you'll start to need to sort that out. Now, what type of information should we worry about under this law? Personal information, right? Now, that wasn't very helpful and I did that on purpose, but the idea is that what actually is considered quote unquote personal information naturally is going to vary according to legal definitions and case interpretation. You see there in the GDPR, personal information is defined as any information relating to an identified or identifiable natural person who can be identified directly or indirectly. So in my mind, the important thing under GDPR to consider is that we're focused on direct or indirect identification of a natural person. In contrast, the California Consumer Privacy Act defines personal information as, and I apologize, I'm pulling up the statute right now just to read it word for word. Personal information from 1798.14 subsection 0 subsection 1. Personal information means information that identifies, relates to, describes, is capable of being associated with, or could reasonably linked, directly or indirectly, with a particular consumer or household. You see that definition reiterated there on the slide, and I just wanted to read it straight from the legislative text to make sure I had it correct. Guys, the important thing to consider here is, again, it's not just the direct or indirect identification, it's also the direct or indirect description, relation, or sheer just being able to be associated or being reasonably linked. That's a lot of potential information. And then to go one step further and make it even more complicated for all of us, again, you'll remember the GDPR is talking about identifiable natural people. The CCPA is talking about a particular consumer or a household. So that's going to be something that's certainly going to be interesting to see how that's interpreted and applied over time. What is this definition of a household? Who applies within the household, without? Does that relate to IP addresses within the household, devices, all of that kind of stuff? It's very, very broad definition of personal information when we look at the California Consumer Privacy Act. Now you see some other laws, right? The key sort of distinction here is that in Europe, they use the term personal data. In the US, historically, we've used the term personally identifiable information. And so often you can tell where someone is from based on the term they use. California has used the term personal information, though. Again, removing that identifiable aspect from the term itself, throwing it in the definition, and then expanding what exactly that means. How can I be identified? Well, anything that directly or indirectly links to me, describes me, could be associated with me, relates to me, and not just me as an individual person, but also my house, right? My household, whether that involves my family, my physical home, apartments, condos, yet to be determined. Now, even further, this is a critical distinction, and it's one that I've often seen missed out there on other blogs and other webinars that I have participated in as I try to educate myself on this law. Nobody is paying particular attention to the definition of a business. Okay, and so the important thing that I want to point out to you guys is that when you look up the definition of a business in section 1798.14C1, it's defined as a sole proprietorship, partnership, limited liability company, corporation, association, or other legal entity that is organized or operated for the profit or financial benefit of its shareholders or owners. So the key thing there is that by virtue of that definition, perhaps it could be interpreted that this law does not apply to nonprofit organizations, volunteer organizations. Essentially, what I'm trying to imply is, based on the way they've defined a business in section 1798140C1, it seems to really only apply to businesses that are operating for profit or financial benefit. And if we compare that with the definition of processing, again, we'll sort of start to remember that the threshold analysis or the jurisdiction of this law deals with commercial benefit on the sale or sharing of information. So in my opinion, this is really more geared towards for-profit private industry, less aimed at public industry, government associations, or nonprofit organizations. Something to consider there if your business or organization operates in that arena. Maybe you can start to do some research and find some legislative interpretations that say you don't have to comply. Now, again, I wouldn't say to ignore this law completely, because presumably something will attack you in the realm of data governance, but that may buy you some time to help develop your compliance processes. The other key definition there is a service provider. Fundamentally, the point I'm trying to illustrate on this slide is that there is a bifurcated understanding of who is responsible for what under the CCPA, very similar to the model that we see in the GDPR. So if you look in the definitions of the CCPA, you will find that this framework is similar to the one established by the GDPR, right? There, a data controller is defined as the organization which determines the purposes and means of processing personal data, right? And you'll remember that our law applies to organizations that collect personal information or those that determine the purposes and means of processing. So again, not necessarily the same as GDPR, but you can see how that legislative theory, that sort of underlying ethos, has found its way in the California Consumer Privacy Act. And that's why I would advise, even if you're sitting here on this webinar and thinking, okay, great, the CCPA doesn't apply to me, you should start to pick up on these theories and topics and ideas, because at some point, when we are inevitably presented with a federal model for data governance, it will presumably have a lot of the same topics and or theories. So again, there's sort of a difference between who's the business that's actually collecting the data, or at least in charge of that collection, right? They're actually creating the instructions and determining the use. And then who's the sort of back-end service provider that's just basically providing instruction or providing a service based on instruction, a limited subset of data processing based on a limited subset of data. You know, the business is the one who's primarily responsible for complying with the CCPA. The service provider is more generally responsible for facilitating and demonstrating how the business itself is complying, right? So supporting the business in its compliance activities. So what does this law require of all of us, right? What are our obligations to our consumers now? Well, you can see some of the rights enumerated by this final version of the CCPA. The consumers have a right to know what information has been collected about them, again, akin to the right of access that we see in laws around the globe. You can see it even goes further that consumers have to actually have a method to access that information. So it's not just that they have a right to know, you also have to actively facilitate the exercising of that right. What does that mean? Perhaps building an account management portal, at the very least maintaining some sort of a privacy office with a centralized email where you can respond to customer complaints or questions or concerns, what they call in the EU DSARs, or data subject access requests, right? Facilitating a process and just thinking about the sheer practicalities of it. Who's going to sit and manage this email system? How many emails come in? How much time is that per day? Does this is this requiring of a full-time employee to manage this activity? Are we keeping records for audit purposes? Where does this fit within the paradigm of our global compliance program, right? All of these sorts of things becoming tangential issues that get spun up as you're thinking about, hey, how do I give effect to these rights to my customers? Now you'll see customers have a right to know the categories of information that have been sold or disclosed, right? So trying to understand, hey, what information do you have on me? Who are you giving it to? If you don't have an understanding of that internally, good God, go out and start to put that together, because you will have to start to be able to prepare that. Again, the idea is maybe this right specifically is enumerated differently in your state jurisdiction, but the idea of transparency, the idea of access, and you see there below that idea of opting out, we're seeing those same sorts of ideas and theories being replicated from the GDPR to the California Consumer Privacy Act to a new law that's coming out in Washington to various other international laws, like I said, in Brazil, India, and Japan, and others, right? So again, I just talked about it, the right to prevent the sale of information. The idea that consumers can opt out of that onward sale of data, certainly something that is going to have a colossal business impact if that is your primary revenue driver. If you live and breathe on the sale of personal information in California, start to think of a new business line, update your resume, and get the parachute ready. Because those organizations based in California that live and die by the sale of personal information are going to face a reckoning with this provision of the California Consumer Privacy Act, right? Just how many consumers and how vociferously will they try to enforce their right to prevent the onward sale of information remains yet to be seen. We've just never really had that sort of a right in the United States. So there's that question, how many people are actually going to effectively exercise it? Now, to that end, consumers have a right to request that a company deletes information collected from that consumer. You'll see there a statutory site. The one key thing I want to note is that is a limited right, just like when we see that right enumerated over in Europe. That's not an all-encompassing sort of a blank check. If someone reaches out to you to request that you delete information that you have on them, you do have some carve-out exceptions for when that data does not need to be deleted. For example, if you're in the process of completing a transaction, if you're subject to a legal obligation, if you're saving that data to maintain cybersecurity, all of those sorts of stuffs. And then, as you can see at the bottom, a very common theory enumerated in all sorts of US laws, there is no discrimination for the exercise of your rights. The idea there is that if a consumer does reach out to you to exercise any of these rights, you may think it's a pain in the butt. Too bad for you. You cannot discriminate against that customer. You cannot make their life more difficult. You cannot try to get them to leave your company based on them actually just standing up and enforcing the rights that they have covered under the California Consumer Privacy Act. Now, somebody had asked a question that came in here, and I apologize for pulling up the screen. Can you give an example of the types of categories of data that they are referring to? Yes, and for that, guys, I would actually point you to the definition found in the statute itself, because for those of you that don't have a legal background, you can often get some sort of insight into legal interpretation based on the actual legislative drafting. So again, if we look specifically at the structure of 1798.140 subsection O, subsection 1, we see that personal information definition, and then we see a non-exhaustive list of examples. And so that's what I'd recommend for you to think about as sort of your categorical buckets. And I'll read those to you here. It's subsections A through K. The first one is identifiers, things like real name, alias, address, passport number, driver's license number, social security number, account numbers, emails, IP address. Keep your eye on that one. Then you have some other ones. Okay, so C, we've got characteristics of protected classifications. That's sort of your things like sexual orientation, religion, ethnicity, that kind of stuff, right? In D, we have commercial information. That can include records of personal property, products or services purchased, or other purchasing or consuming histories. In E, we have biometric information. In F, we have internet or other electronic network activity information like browsing history, search history, information regarding a consumer's interaction with a website, maybe cookies. In G, we have geolocation data. In H, we have audio, electronic, visual, thermal, olfactory, or other similar information. Again, kind of that idea of the Amazon Alexa world. In I, we have professional or employment-related information, references and resumes. In J, we've got education information, although that's defined as anything that's not publicly available already out there in the system. And then in K, we have inferences drawn from any of the information identified in this subdivision to create a profile about the consumer, reflecting their preferences, characteristics, psychological trends, predispositions, behavior, attitudes, intelligence, abilities, and aptitudes. Wow, that's a mouthful. So as you can imagine, right, there is almost no data is not within scope of this new law. And again, you can see by the sheer size and style of their data categories that they are particularly focusing on a large number of pieces of personal information here. Now, so I'll try to wrap this up quickly because I want to save time for questions and I'm conscious of time. What information do companies have to provide to consumers? They have to provide a myriad of information, right? And essentially, in the converse of what you saw on the previous slide, you just have to sort of meet their rights. Be transparent about the information you're collecting, give insight into your processes related to data collection and data processing, also your business or commercial purposes for why information may be collected or processed, and who you may be sharing or selling that information onward to. Basically, it's the same sort of an idea that, hey guys, if I let you borrow my car, what's your driving history, where are you going, who are you going to give it to, that sort of common stuff. Now, again, the law gets more specific in how we actually have to operationalize it, but not terribly much. It does tell us that we need a clear and conspicuous link to a do not sell my personal information, sort of a button that kicks off that process. And then also you have to explain these enumerated rights, perhaps as a privacy policy, or especially if you maintain any sort of California-specific policy information, it would need to be listed there as well. Now, what sort of security is required by this law? Well, a typical lawyer answer there. You need reasonable security. Unfortunately, that's not very helpful. That's somewhat similar to the definition we see in GDPR Article 32, like I said, right? Reasonable measures that are technical and organizational. State laws have the same sort of a standard as it relates to data breaches and the liability there. The one thing I would sort of tell you to consider, again, the drafting, the framing, the way they write this stuff. Okay, so they're saying that you need to have reasonable security procedures and practices. What does that mean? Well, what is reasonable is actually relative to your organization and the context within which you operate. So what I would tell you, based on the structure and styling of the GDPR and the way they have drafted that law, consider a risk-based approach to security. Don't just start applying security controls based on what you think is the latest and greatest gadget that's going to lock it all down for you, because inevitably somebody's going to screw that up. You need to think about a risk-based approach and trying to develop that model. Again, it's more of a programmatic model to understand where is our risk and what are we doing relative to that risk to address it, as opposed to, say, encrypting everything or putting everything on the cloud, right? It's having more of a flexible, tailored approach. And this is currently considered international best practice, right? At least according to the ISO standard and some of those other control frameworks out there that I mentioned, NIST, COVID, and others. It's not about applying security controls in mass and in blank. It's about taking a risk-based approach to tailor it to the needs of your organization. So a lot of people often ask, does the California Consumer Privacy Act deal with data breaches? Not specifically, but again, California already has this codified in statute in a separate part of their civil code. So if you're kind of Googling around and you're looking at blogs and you're digging around on legislature.ca.gov, you may not actually find this stuff. So keep in mind that every state has data breach notification laws. And like I said, some of those actual currently existing requirements are going to be slightly different from what's required here. As an example, if you are responding to an access request under California's data breach notification law, there's a timing requirement that is slightly different from the timing requirement enumerated in the CCPA. I don't remember off the top of my head, but it's somewhere in the difference between 45 and 30 days. So under one set of law, you have 45 days to reply, and under one set of laws, you have 30 days. You'll have to carefully articulate which laws apply to which activities to more clearly outline your requirements. That is, unless, of course, the California legislature steps in and does a little bit of legislative cleanup on our behalf to make things a little bit more smooth in the interim period before January of next year, January of 2020. Now, what are the differences between U.S. state laws? Frankly, it's that trifecta right there. You sort of see that, again, every state has a data breach notification law, but they differ in terms of what is covered personal information, what are the timing requirements, so what needs to be said to whom by when, and then, of course, those back-end penalties that apply. All going to be different. So that's why you can't sort of address this in an ad hoc approach. You can't focus on California and then Nevada and then Utah and then Washington. You have to step back, escalate it to a higher level, and think about a more framework style, more program or department style approach to this liability risk, as opposed to say, here's a law, here's what I need to do, here's what I need to be doing differently, right? This is not like a speed limit where you are either in compliance or you're not. This is a much more nebulous, gray sort of an understanding of what's reasonable for your organization, what's appropriate based on the risk involved with the data, and what are you doing as a result based on your industry and sort of where you operate. So what types of companies are going to be involved here? All types you saw. Providing goods or services to those California residents. You can also think about any sorts of other economic activities. The interesting thing that I would sort of differentiate between the CCPA and some of these other laws we mentioned earlier is this idea of consent, right? And surely if you're familiar with the GDPR, you are at least familiar with the idea of consent and how consent is required for data processing. So far, we have not seen that same idea be articulated in U.S. law quite so substantially. Something to keep an eye on, but it is somewhat of a fundamental difference between our approach here in the States and others we're seeing around the globe. Now, what are the penalties? This is an interesting one that's still subject to evolution. So I'll try to wrap this up quickly so I can open it up for questions. All cybersecurity and privacy laws include penalties of varying degrees. The thing you need to remember here is number one, under the current iteration of the CCPA, only the Attorney General can enforce those higher level of fines, set up to $7,500 per violation. A private right of action does exist for consumers, but it actually only relates to actual damages or statutory damages as listed here, right? So if I have my identity stolen and somebody goes and buys a Winnebago on the internet using my credit card, I could sue a company for the cost of that Winnebago so I could be made whole. But if I haven't had my identity stolen yet, I'm only looking at a potential cap of $750 for the sheer inconvenience of my data being breached. Now, I say that this is under evolution because current legislators in Sacramento are pushing forward bills and amendments to reinstitute that private right of action mentioned earlier under Alastair McTaggart's original proposal. That would give effect to statutory enforcement of all other pieces of this privacy law. So again, essentially right now, all that exists is a private right of action for a citizen to say, you had a data breach and that caused me harm. Either someone stole my identity and spent money, or they haven't yet, but they maybe will, and so I need $750 because you weren't maintaining reasonable security. There is new legislative amendments that would suggest that they are trying to reincorporate the idea that any citizen could sue any company for violation of the law, and that would potentially open a wide and unknown door. Don't focus too much on the numbers here because think about it. What about class action lawsuits? Potentially millions of aggrieved customers looking at $750 to $7,500 per violation. That can quickly balloon into the millions of billions of dollars. So something to consider there. While the GDPR is often thrown around in the news for the heavy hitting fines that are potential under there, right? 4% of global annual revenue. It remains to be seen just how powerful the CCPA's enforcement mechanism will be there as well, because potentially it could be a lot more than 4% of annual revenue. So guys, I'll kind of return here with a quick word from our sponsor. There's a lot of next steps you can take to educate and arm yourself in preparation for the California Consumer Privacy Act. So right now at IT Governance, this is our sort of a contact page. You can find us out there on social media, phone, email, website, etc. We've got a variety of existing products and services that we think would help. A lot of tools and technology geared around GDPR implementation, again, because a lot of the theories are the same, and especially if you haven't reached a mature level of compliance with that law, it would be something to consider. Over the course of this month and next, we're actually in the active development of new products and services geared toward the CCPA specifically. Things like gap analysis services, on-site consulting activities and audit activities, implementation guides, and a certification course that you can take to learn about this stuff in more drilled down detail and really arm yourself with the knowledge you'll need to understand the legislative history of this law, where it's come from, where it's going, and as a result, what you need to start doing to prepare. So I hope you found this information valuable, and like I said, there's no shortage of resources. You can reach out to us for more information on GDPR, or if you want to launch ahead and you find you're in a mature state of compliance, get ready with your ISO implementation, bring that into play would be helpful as well. As a special thank you for our attendees today, you'll get a 15% off discount code. So as soon as you take our webinar survey after this call, you'll be eligible to receive that code. If you don't receive it, please don't hesitate to reach out to us through our dedicated sales channels, our communication functions, or you can always find me on LinkedIn very easily, just Preston Bucati, pretty much the only one in the world with that name, so I'm very easily Googleable, and frankly, that's why I take data privacy so seriously. Again, I just want to thank you all for joining. I apologize for running a little bit over. I'm going to open it up to questions now, and I had some come in. Okay, so the first one here, would a law firm be subject to the CCPA given that there's a lawful basis for the collection of personal information? So I would question what that lawful basis is for the collection of personal information. What I always tell my clients is, can you point to me a statutory citation, an actual law that says you are required to collect information? If you can't, you probably don't fall into that exception. Now, that's not to say you may not have a basis for collecting information for other reasons, sheer business reasons. And don't forget, guys, the CCPA, much like the GDPR, is not saying you can't process information. It's not saying you can't collect data. In fact, under CCPA, there's not really the same idea of lawful processing, although that's perhaps something a little bit more drilled down for the 60 to 120 seconds we've got here. But what I would tell you is that no, I would find it highly suspect that any private organization claims that they have a legitimate legal reason to collect information outside of a pending subpoena, warrant, or lawsuit. Now, that's, again, not to say that there aren't valid business reasons to collect the data, and that may be a justifiable purpose for processing under the CCPA. That would, frankly, require a little bit more analysis and understanding than what we maybe have time for right now. Now, the next question is CE credit offered for attending today's webinar, specifically CLE credit. I assume the CLE stands for continuing legal education credit. I would tell you based on my own experience in that world that no, the webinar today is not offered specifically for CLE credit, and it has not been approved by any state bar associations. However, that is not to say that you couldn't make the case to your state bar exam. If you want copies of our slides or other information to help fill out that paperwork, I'm happy to help you with that because I do that constantly. I am barred in both Colorado and Missouri, so I have 30 hours of annual requirements that I'm always trying to fill out paperwork based on webinars I attend. So if you've got questions more related to continuing education credit for today's webinar, feel free to reach out to me directly and I can try to help you through that process based on the bar associations I've worked with and their processes on getting webinars accredited for CE credits. Now, another question to that end, is this webinar being recorded and will it be sent out? Yes, yes. So the webinar is being recorded. It's just me talking, so thankfully none of your privacy rights should be impacted here. But we will record the webinar. We will send out slides, so please stay tuned for that. And again, if you don't receive that in a couple of days, please feel free to reach out to me directly or to our team, and we'll make sure we get a copy out there over to you. The last question I had come in here is, can you talk a little bit about exemptions such as the GLBA? Now, I can and I can't, and I apologize, that's a typical answer too. What I can say at a high level is that the law, the California Consumer Privacy Act, does create a variety of exemptions and exceptions based on compliance with existing laws, right? So, for example, there are, you know, you may already be under requirements to deal with laws like HIPAA or the GLBA, as it were, right? And to that end, I don't remember the actual citations within the California Consumer Privacy Act, but I'm fairly confident that they're in there. And it's also a pretty sort of standard approach to U.S. legislation that they will carve out exceptions if you're already under pretty much the same requirement, right? So I have seen a lot of language in those state data breach notification laws that if you're already under a breach requirement notification that's substantially similar, let's say from HIPAA, you know, if you follow that process, you will be deemed to be compliant with this law as well. So something to consider there. But that's a great question, and you would need to look into in a slightly more detail that level of overlap and exemption between those laws. But that's a great question, and again, presumably at a high level, there would be some sort of carve out. So if you're already subject to SEC laws or those sorts of things, you wouldn't have to be tripping over CCPA compliance as well. They would sort of say, hey, look, you're already meeting an obligation with due respect to privacy rights. We will give effect to those rights, even if technically they're coming in under a different acronym. So if there are any other questions, I'm happy to hang around and answer them. You feel free, of course, to always reach out directly or indirectly, and we'll shoot those out to the attendees today. I always love sharing information with folks to try and, again, excuse me, educate them and arm them. The last question I had rolling in here is all of this within the state of California? And again, I would say so far that seems to be the case. The real question that is going to come up out of this law is, how much will it apply extraterritorially? So for those of you that are really deep on this topic, there is a law in Illinois that deals with the collection and processing of biometric information. That law has been sort of interpreted to really only apply to actions in Illinois. But as you can imagine, there's a question when it relates to technology. So if I'm a Facebook user and a friend of mine uploads a picture of me, and Facebook's algorithm automatically goes through a biometric process to sort of suggest who I am. I sort of, hey, do you want to tag this as Preston based on the shape of his face? Well, Facebook has just engaged in biometric processing. The question becomes, where actually did that processing occur, right? I'm a citizen of Colorado. Facebook is based in California, but they have operations around the world. So where exactly was that processing taking place? Does that make it subject to either general or specific jurisdiction of Illinois? That's sort of what I was talking about there. And again, that kind of gets into a legal wormhole. I'm happy to nerd out on it with anybody. I just spent the past couple of days really researching that issue and the history from the US Supreme Court. But ultimately, guys, what I would sort of tell you is, if you're operating outside of California and you don't have a physical presence in California, focus on the activities you do when you deal with California residents and try to tie it to that way. So if you're processing data of California residents, let's say the processing occurs at your home base in New York City. Well, in that case, the harm is maybe not actually affecting California residents in California, right? And so maybe you are more strictly required to comply with laws in New York, but not necessarily California, just by the sheer virtue of the fact that people go on the website from California. Again, that's very fact specific, and I'm almost cautious to even say anything here because now I'm getting in the world of legal advice and I don't want to give anyone bad advice, but I would sort of say narrow down your focus on what are your activities with California residents in that state, and now residents out of state, start to maybe sequester that as a potential pocket of liability that may need to have more information as case law gets interpreted or as the Attorney General from California gives us any sort of guidance on where this law is going. Hopefully that was of value to you guys. Again, I appreciate you all joining. Feel free to reach out to me directly or indirectly for more questions, comments, concerns, and we'd enjoy seeing you next time on our revolving slate of webinars dealing not only with California's new law, but others around the United States and the globe. Again, I'm Preston Bukaty for your IT Governance USA, signing off. Thanks for joining as always, and we hope to see you again next time. Okay, if anyone at ITG is still here, I am done. I have exited the presentation. So what does that mean for us? That means that we need to prepare the recording and all that good stuff, right? So let's do 12 to 12:30 webinar cleanup, format recordings. So, Save and close. Okay, no emails over there. That's good. All right, in that case, I think I can stop, quit, record, end webinar for all.